Let's resume. I'm going to come to you, Mr. Henderson.
Sir, I'm very grateful. I'm going to deal with the numbers point first because it's easier to just clear that off the deck straight away. So, H59 and the question that you asked us in the last phase, that's going to be a subject of a note, but that doesn't go to the policy that's before you today and which you're considering. So that's the first part cleared away. The second part is paragraph 9.8 F, Roman numeral 1, in the supporting text, and the fact that there are those missing numbers. The very short point here, and I think Mr. Bewley was almost there in his own submissions, is that this doesn't go to the principle of the policy that's before you and the bigger question. It's included there by the Council as an attempt to be helpful, but importantly, it is subject to the evidence. The Council needs to see evidence that meets the relevant standards, which demonstrates that there can be any netting off of the site. It could be, on the review of evidence, that we don't think that evidence is good enough, and the answer is that figure is 0. We're not there yet. We're looking at the evidence that is provided to us on the 6th of September. We're consulting Natural England on that, and once we finish that process, we'll return to that paragraph to work out if we can put a positive number in that at all. That's all I need to say on that, sir, because it doesn't really go to the principle of this policy and Mr. Bewley's first 2 points. So that's that. Turning then to the principle of the policy, my first subheading is soundness. And it said, well, it said against me, this policy does not need to be included for the purposes of soundness. And the very short submission in response to that is, no, it does need to be included, and it needs to be included in order for the plan to comply with the habitats regulations. That's the short answer. Let me explain to you why that's the case. Regulation 105, paragraph 4 of that regulation, that's the prism through which we approach this. When we look at Regulation 105.4, it asks us to consider the land use plan. The authority must give effect to the land use plan only after having ascertained that it will not adversely affect the integrity of the European site or the European offshore marine site, as the case may be. What is the land use plan? Well, see Regulation 111. And as I think is common ground, it is the plan that is before you, is a land use plan for those purposes. But importantly, it is the plan in its entirety. One must assess all of the land use plan. One is not restricted to assessing, for example, only allocations. And that's significant in this case because of windfall development. The Council sets its housing target, policy SS1, we've looked at already, and it plans for that growth. And as you know, and as Ms. Bartels explained in her evidence, meeting that growth will, at least in part, be through windfall development. That's part and parcel of the land use plan when you read it as a whole. Now, why is that relevant here? It's the question of uncertainty. We cannot rule out windfall development within, for example, 400 metres of the common. It could, for example, be Mr. Bewley's clients without an allocation, but nonetheless saying, well, actually, we think this site deserves planning permission, and we're going to put in an application on a windfall basis. I don't understand Mr. Bewley to be saying that his clients won't do that. And it's the uncertainty about where is that windfall development going to land. We cannot rule out that it may be in an area which will affect the common. And that is the analysis which one sees in the HRA. I'll take you to that very quickly just to make good that point. So CYC 45, and within that document, sir, I think it's a reference you were given before, it's PDF page 124. And on page 124, we get the subheading windfall development where this is considered. So I'll wait till you're there. Yeah, so PDF page 124, this is the windfall development at Strensall Common that's being considered. And if you turn over, please, to page 125 in the PDF, paragraph 4.2.33, whilst the impact of individual allocations has been addressed above, it remains that unallocated development provided for by the policy may be proposed in, I should say it's not just that policy, may be proposed in close proximity that could conflict with the conservation objectives. And if we, what we then get 4.2332 is reference to where this is done elsewhere, most of which I'm sure you're familiar with. Thames Basin is the most obvious example. And then final sentence of that paragraph, the absence of this requirement in policies within the plan potentially allows inappropriate development in close proximity and increase the risk of adverse effects arising. Therefore, without adequate policy protection, adverse effects cannot be ruled out in terms of policy. So that's the uncertainty point, sir. We know that windfall is part and parcel of the land use plan, but what we're not sure is that it will be a sufficient distance from the common for us, for the purposes of HRA, to be certain, beyond reasonable scientific doubt. We can't have that certainty. It's an unknown. So what's the answer to that? 4.2.334. Therefore, to remove this risk, it's recommended that the same mitigation measure is adopted at Strensall. And it's that mitigation measure which you have in Policy GI 2A as it's before you. So it is dealing with the uncertainty. Once we have removed that uncertainty, we can then reach a lawful conclusion that there's no adverse effect on integrity for the purposes of Reg 105. Next subheading, evidence. Mr. Bewley's other complaints, he says there's not evidence to justify the approach and the submissions that I've just made to you. I don't accept that for two reasons. Firstly, there is the evidence. I'll take you to it now, if I may. CYC 45A, so this is the appendices to the HRA. Within that set of appendices, we get Appendix D, which starts on PDF page 64. And that's the footprint ecology Strensall Common Visitor Survey. It's not paginated. Have you got Appendix D? Hang on, I'll pause whilst Mr. Bewley.
So I've got the footprint visitor survey, etc.
Yeah, and if you look on the second page, that should be dated 12th of February 2019. Yeah, that's the document. I literally was taking the inspector to that page that's in front of you, Mr. Bewley, just to make sure we had the right document. So within that, can I ask you to go forward, please, to PDF page 74, and for Mr. Bewley, it's internal page 3. And you'll see paragraph 112, we're dealing with the introduction, it's telling you what is being done here. Following the advice from Natural Inn, the City of York commissioned this work, which aims to, then we get the aims. And these are general aims to examine the impact of recreational disturbance on Strensall Common. They are not tied to any particular allocation. That's paragraph 1.12. We can see that in the method as well. So, for example, PDF page 74, that's page 6 for Mr. Bewley. Under the subheading Methods, Overview, paragraph 2.1, visitor field work, including the following: face-to-face interviews, direct counts, car park counts, automated. What was being done was a generalised survey to consider everybody visiting the common, wherever they may come from, and to understand what the potential effects were. Skip forward, if I may, to section 7 of this document, so that's PDF page 118, page 47 for Mr. Bewley. This is the house change and implications for levels of recreational use. And this is where the analysis, following those surveys that I've just shown you, is undertaken. And we get a number of tables, table 18 and then figure 12. And I draw attention in particular to PDF page 120, page 49 for Mr. Bewley, paragraph 7.4 and figure 13, which accompanies it. That looks at all of those survey results, wherever they may arise from, and plots them to understand what the effect is. So none of this is restricted to an assessment of allocations. It's about understanding on a non-site specific basis what the impact of recreational pressure is on the common. And it is from this evidence base that we get those conclusions that I showed you in CYC 45 and the HRA itself. So the first answer to Mr. Bewley's evidence point is, well, no, there is evidence and it's there. It's not site-specific in the way Mr. Bewley tried to characterise it. It deals with the common generally. That's the first answer. The second answer, though, sir, is even if I'm wrong, even if Mr. Bewley is right, and that is a site-specific survey which is only dealing with his client's allocation, let's assume that that's right. Even if that's the case, it's still good enough for my purposes. And the reason why is because it shows, for Mr. Bewley's own site, the potential effect. And because we cannot rule out Mr. Bewley's own site coming forward as a windfall development, it illustrates precisely the uncertainty that I am concerned with and which the HRA is concerned with. When the council, I should say, adopts this land use plan, it will include windfall. That windfall could include Mr. Bewley's clients bringing forward a site. That is uncertain, and it is uncertain with this site-specific evidence, if Mr. Bewley's right, which shows you that uncertainty. So what does the council have to do under the HRA process and through the habitats regs? It needs to rule out that uncertainty, and it does that through this policy, sir. So I go back to Red 105. This policy is required in order to rule out that adverse effect on integrity, in order to comply with Red 105 subparagraph 4. So is it necessary for soundness? Yes, it is. Without it, we can't comply with Red 105. So whichever way you put it, Mr. Bewley's principal point or his evidence point, it makes no difference. This policy needs to go in for the purposes of soundness.
Thank you, Mr. Henderson. I'll come back to you, Mr. Bewley, of course. Go on.
Thank you, sir. Now, yes, I'm grateful. I'll take the points in the order that Mr. Henderson made them. First to a shorter, and then slightly longer on the other 2 points. But first point is H59. Obviously, that's to be confirmed in a sense. It's work in progress. I completely accept that. To that extent, that's not a matter for today. But Mr. Henderson is wrong to say that it's irrelevant to today for this reason. His client's position as at today is that it's looking into whether the site allocation at H59 by itself, which is a site that's within 400 metres of the common, can be permitted even though it's within the 400 metres. So he's not in a position to say, as I don't know what the final outcome of that process is going to be, but certainly as at today, he's not in a position to say that there's no, that for example, even that H59 can't take place, can't be developed so as to rule out adverse impacts, because his client hasn't reached a conclusion on that question. And if they were to conclude that H59 could be developed in that way, that would simply be flatly inconsistent with the policy that's being proposed for today's purposes. So it's illustrative in that sense of the basic problem. Just as he's not in a position to say that another windfall site, let's say it involves half the number of houses of H59, so 20 odd, that's inconsistent with the policy. Definitely not in a position to say, I'll come back to this when we look at the evidence, that couldn't happen without an adverse impact on the SAC. So H59 is relevant in that limited way. Second point is the netting off. Numbers to be confirmed, I completely accept that. It's not right to say, however, we never provided the evidence. We've provided the evidence throughout, and it's simply the evidence of how I don't understand it to be capable of much dispute, of how many single dwelling units there are, how many family units there are, how many transitory bed spaces there are. My client's in a position to know that as a government body. It's not going to lie about it. And we've supplied that information not only since the August modifications were produced, but we've supplied it in the past, as one of the paragraphs I read out to you showed. Now, we've updated the numbers because these things change. So the basic idea that there are those units, or those unit equivalents, if you like, can't be in dispute. The point I'm making to you today about that is not, well, should it be 167 or 150 single bed spaces or something like that. I mean, that we can sort that out between ourselves, hopefully. There's now accepted to be a netting off exercise, which must produce some significant numbers, even if it's only 100, which has never been taken account of in their analysis. And that's the problem, which I completely accept doesn't go to the issue before you today. It goes back to the issues before you in July. We welcome the new approach, but we've made it today because this is the first time they made the concession in that way. So that's the point about that. Third point is the in-principle legal point about how you understand the habitats regulations. Now, I have to say, I do invite the Council to think very carefully about this, because if it maintains the legal position and you accept it, it's either legally wrong or it's legally right. So, but I don't want to sound, I hope that doesn't sound like a threat, but I hope that it will also consider its position, because it would have pretty significant implications if it maintains that. Now, is it right? Absolutely not. The reason that what Regulation 105, Mr. Henderson is right, and I referred to this provision I took you to, the relevant provision is Regulation 105.4. What Regulation 105.4 provides, and it's focusing on the plan as a whole, again, Mr. Henderson is right about that, does the plan adversely affect the integrity of the relevant sites, the European sites, or site? So if you adopt the plan, in other words, does that have an adverse effect on the site? Now, if you adopt a plan which has a site allocation, the development of which would so adversely affect the relevant site, then you have a problem, because the plan establishes the principle of the development. And when the planning application in due course comes forward, although, as it were, you can play around at the edges, you can't dispute the principle of the development on that site. And so you approach your habitats assessment essentially on the basis that you've got a lawfully adopted policy that's already been assessed, and therefore you approach your planning application in that way. That's the problem. That's why the adoption of the plan, because it commits you to the development, it creates a risk to the site. And that's why it's no answer in relation to that for me to say, yes, but there'll be another process at the Regulation 63, the planning application stage under Regulation 63, where these issues will have to be addressed again, because they won't allow you to go behind the principle of the development, or you get into an argument about which takes precedence or whatever, but that's... So that's the problem there. That problem doesn't arise if the plan just has some general policies. And because it hasn't committed to development. There's no risk to this Strandsell Common SAC just because someone makes a planning application, that's the risk that Mr. Henderson is now adverting to. It's the risk, he said it in these terms, it's the risk that, for example, my client makes a planning application, which let me be clear, we may very well do. I wouldn't be bothering about this point, I suppose, if we weren't thinking about that as a fallback, obviously. And we may very well do. I mean, I don't know if we will, but we may very well do. But if we do that, then there will be an assessment. There will have to be I think it's probably, in the light of what's happened, no one's going to dispute there's going to have to be an appropriate assessment at that stage. I mean, in theory, you could say, well, it's only 20 houses, maybe you don't need it, but anything significant is likely to have it. And the issue can be looked at. And if the outcome of that appropriate assessment is that it's okay because it's, 200 units or whatever and the mitigation is, well, fine. No harm to the site, because you've ascertained that it is acceptable. There's no reasonable scientific doubt, etc., about the impact. And if the outcome of that assessment at that stage is, no, actually, you still can't be sure, then you refuse planning permission. Either way, the harm to the site doesn't occur. So it's fundamentally wrong to say that just the risk of the planning application or the risk of windfall sites coming forward in the sense of someone else making an application or having a go, that's the kind of risk that Regulation 105 is concerned with. And it's worth thinking about what the implications would be if that's wrong. It would mean that every single site in the council's area, every European site in the council's area, not just Strandsell Common, but every single one, should have a 400-metre buffer zone policy around it. The reason that hasn't arisen for other such sites in the area is only that there doesn't seem to be this issue hasn't arisen in the same way because there isn't a site allocation next to it. But as a matter of logic, you can't escape it. So Mr. Henderson, with respect, is just legally wrong on that. The last point is one about evidence, and he makes 2 points. One is a point about the detail, and one is a point, an even more ambitious point of principle. So let's take them in turn. The evidential point is that he said, well, actually, interestingly, he goes not back to the HRA itself, but to one of the documents appended to the HRA. And the document he goes to is, I think, please someone can tell me if I got it wrong. I think it's Appendix 2, but I don't have the... but anyway, it's the footprint, it's the original footprint visitor survey. And he took you to various, and he's right, I think, so far as it goes, that that's generic in itself, that visitor survey is generic, because it's looking at visitor numbers and trying to form a view about what the increase would be by reason of development of various kinds. But the critical point on that is to look what its actual conclusions were. And I'm sorry, I don't have the PDF number, but you'll see that starting at internal numbering 73. If someone else wants to shout the PDF number, that would be great. Section 10 of the... What is it? 144 of the PDF. And the heading to that section is 10, Discussion and Implications. And it's absolutely critical to see what this footprint survey concluded. And you can see that actually at 10.5 on the same page. Given the scale of increase...
Sorry, could you just read out 10.4 before you do 10.5?
Sure. Well, sure. Our predictions suggest an increase in access of 24% as a result of the quantum proposed housing in the City of York plan. That, of course, is a reference to the figures we looked at last time, which are both this site and other sites. We looked at that in some detail last time around. Yeah. So as I've said, it's generic in that sense. Marked change, etc. 10.5. Given the scale of increase in access predicted from the visitor surveys, the proximity of new development and concerns relating to current impacts on recreation, adverse integrity on the SHC cannot be ruled out as a result of the quantum of development proposed. In addition, for individual allocations, and it does actually descend into some detail about them, never mind, that are adjacent to the site, it will be difficult to rule out adverse effects on integrity. Potential approaches to mitigation are considered below. So the conclusion there is not you can't mitigate it. The conclusion there is mitigation will be needed and we'll need to look at it in detail. There's then a heading, potential approaches to mitigation, and it's lots of things are looked at and various issues are discussed. possible difficulties are identified and so forth. And the conclusion of the final conclusion of the footprint survey, you can see in 10.19 and 10.20, is not that you can't mitigate. It's simply that mitigation will need to be looked at in greater detail. So 10.20, at plan level HRA, it will be necessary to have confidence that the above mitigation measures are feasible and achievable in order to rule out adverse effects on integrity. At subsequent project level HRA, it will be necessary for the details of mitigation to be confirmed and so forth. So it's absolutely not saying this survey. This survey in itself is absolutely not saying you can't mitigate the impacts. It's saying you will need to think carefully about how you mitigate them. Now, this was a point that was discussed in some detail. I know Mr. Henderson wasn't there. The last time we looked at the detail of this, which I think it was in December 2019, so I think maybe you weren't there as well either, actually, but there we go. But we went into all of this, and the council had produced an earlier HRA, and we made exactly the point that I'm making to you now, because the earlier HRA effectively said, well, look, our justification for saying you can't mitigate is the footprint survey, and then when you look at the footprint survey, it doesn't actually say anything of the kind. That's why the 2020 HRA looks at mitigation in the way that it does and doesn't just say, well, actually, the footprint survey's already done the job. So if Mr. Henderson's evidence for a generic problem is the footprint survey, then with respect, he's fundamentally, and his client has continued to fundamentally misunderstand it, because it doesn't say you can't mitigate adverse impacts. It just says you need to think about how you do it. And it's right to say identify some potential problems and so forth, but that's as far as it goes. And it's pretty striking that now that this point has arisen, that Mr. Henderson hasn't taken you back to the 2020 HRA and says that that is how you show a general problem rather than a site-specific problem. He's only taking you to this document, and that doesn't reach any conclusions. So that's the answer to his evidence being, well, actually, we've got detailed evidence, it's in the footprint survey. What about his more general point? Well, his more general point is, I struggle to understand it, I think it relates to the last point, but his more general point appears to be that the mere possibility, again, it's the mere possibility of windfall sites coming forward is what gives rise to the risk. In other words, we haven't satisfied ourselves that windfall sites could take place without adverse impacts, and we haven't satisfied ourselves that no one will apply for windfall development, and therefore we can't be satisfied that adverse impacts will be ruled out. But that's back to the fundamental misunderstanding of the habitats regulations that I previously referred to. The reason a plan will be unacceptable under Regulation 105. A planning permission will be unacceptable under Regulation 63 because it grants planning permission for a development which will have an adverse impact, or where adverse impacts can't be ruled out. A plan will be unacceptable under Regulation 105 where it establishes the principle of development of a particular kind, where that development cannot take place so as to rule out adverse impacts. But the mere possibility, the fact that the plan doesn't actively rule out such development, where it still falls to be assessed under Regulation 63, doesn't make the plan unlawful. And if it were otherwise, I mean, half the plans in the country would be unlawful. Because you'd have to identify every possible development that might harm every single European site in the country, and rule it out ab initio, regardless of the possibility that someone might come forward with more detailed evidence in due course. So his detailed evidence isn't there. That's because he's wrong about the footprint survey, and his generic point is much too broad. So,
Thank you, Mr. Bewley. I'll come back to you, Mr. Henderson.
Yeah, thanks, sir. Full point. First one is under the habitats regulations, the in principle subheading. And Mr. Bewley says, well, what I'm concerned about is the risk of a planning application. That's not right. The plan plans for a housing figure which includes windfall. Windfall development is part of the plan and is part of meeting that figure. It's not just the application for windfall, it is the delivery of windfall which is part of the plan. Think about it in the usual terms. Mr. Bewley's client puts in their application and comes forward and says in their planning statement, we will contribute to meeting your housing need as set out in your local plan. No doubt about it, that's what his planning statement will say. Why does it say that? Because of the figure in the plan and because of the level of need that has been planned for. And the council has been very clear and has evidenced that it will need to rely on windfall delivery in order to meet that housing figure which is being planned for. So it's not the possibility of an application coming forward, it is the fact that the plan is anticipating and expecting the delivery of windfall. And that is why windfall is part of the land use plan for the purposes of Red 111 and the purposes of Red 105, even though it doesn't have Mr. Bewley's in principle stamp on it. Doesn't need to in order for it to be part of the land use plan, because the housing requirement that is being planned for is premised, fundamentally premised, on the delivery of windfall. And once that is corrected and you understand that that is part of the land use plan, the problem of uncertainty, where's that going to come from and where's it going to go, arises in the way that I've already described, and that's what needs to be addressed under 105. So that's the first point. Second point under the subheading evidence and the footprint survey, Mr. Bewley says, well, all this doesn't do what I need it to do for present purposes, because all it does is say, well, you'll go away and you'll have a think about mitigation. But what you'll see, paragraph 10.6 in the section Mr. Bewley took you to, final sentence, in these areas, SANS are considered a suitable mitigation only for development set back from the European site boundaries, brackets, beyond 400 metres. So yes, go away and think about mitigation. Some sites you might be able to mitigate, but we know in that 400 metre area, which is what we're really discussing today, that's not going to work. I'm relying on everything that Ms. Elvin said about the 400 metres and previously. I don't need to repeat that. So this does make good the point of uncertainty. Yes, we've gone away and thought about mitigation. Where might mitigation be possible? But also, where might it not be possible? Well, actually, what you've got before you today, GIA 2A, is an example of us saying, well, look, we don't think we're going to be able to mitigate that by putting a SAN within 400 metres. So we're going to impose this policy in those terms. The third point, same subheading of evidence, Mr. Bewley says, well, I'm ignoring the 2020 HRA, not at all. I took you to it, but why did I take you to this document? It's in the appendices to the HRA done in 2020. It is one of the documents that is drawn on by the HRA in 2020 for its conclusions. So when I took you to CYC 45, PDF page 124 and following, when it talks about recreational disturbance, it is on this basis. Indeed, I'll give you one specific reference. PDF page 125, Mr. Bewley's page 123, paragraph 4.2.335, PDF page 125, sir. Yeah. You'll see 4.2.335, final paragraph on the page. I do want you to get there, so I'll pause. And you'll see at the start of that paragraph, it says, mindful of the visitor survey evidence. Opening words of that paragraph. What's that talking about? Well, it's talking about all the visitor survey evidence that's in the appendices. So I'm not dodging or diving or ducking or weaving when it comes to the HRA 2020. I'm dealing with it head on. Everything I've said to you is entirely consistent with what's there. The final point, Mr. Bewley's more general point, he says, well, think about the consequences, see you in court and all the rest of it. A couple of really short points on that. This council is not the outlier here. Look at all the references in the HRA to where this is done. Breckland, East Devon, Cannet, Wealdon, Dorset. There's probably others that I've missed out that you'll have come across in your own work. This is entirely common. It is, I'm afraid, Mr. Bewley's client that is the outlier. And Mr. Bewley says, well, my general point's not right because it's not actively included. I'm afraid it is actively included, and I take you back to what I said about land use plans. Windfall development is part of the number that is planned for. It's not just the possibility of an application, it is the delivery of windfall, which is why every single windfall application that comes forward will say, we are delivering to meet your housing need in the plan. So that's the fourth and I hope final point on it. But in short, we need this policy to meet Red 105 and in order for this plan to be sound.
Mr. Bewley,
I'm sorry to be a nuisance. I would like to come back very quickly.
Yeah, we'll do one more.
Yeah,
I
exactly.
think.
Well, I mean, I'm going to take. We're shortening each time, hopefully. Mr. Henderson made 4 points. I think I can take 2 of them together. But the first point was about windfall development and how the plan commits to windfall development, which I'm being told different things about whether that's right in terms of their general approach. Let's assume it is. There are 2 critical points. First of all, it is, as I understand it, and has to be the council's positive case to the inquiry that it can meet its housing targets, notwithstanding the deletion of these site allocations, the ones relating to QEB, etc., ST35, H59, and furthermore, on the basis that this new policy is adopted and therefore rules out development on those sites. So its positive case to the inquiry is and has to be, because otherwise its plan will be unsound for other reasons, is and has to be that it can meet those housing targets without development on this site. So no developer can then come forward, including my client, and say, well, notwithstanding that, you're committed to giving us planning permission because we've got to meet that because of the housing targets, which can only be met by reason of windfall development on this site. It will be contrary to the council's case, which on this issue I'm not asking you to depart from what they're saying. And therefore, by definition, the plan can't commit you to development on these sites in particular by reason of the fact that just because they come forward as windfall. But secondly, and more generally, of course it's right that you look at the plan as a whole, and of course it's right that a developer who wants to get planning permission on ST35 or any other site that would be affected by the 400-metre exclusion can point to windfall, can point to the desirability of windfall development. Indeed, he can even point to the desirability of windfall development even if the housing targets are being met. It will be a material consideration in favour of planning permission. But it is a material consideration which must, as a matter of law, be overridden by any conclusion about the inability to rule out harm under, in other words, the Regulation 63 assessment. So you would, as a matter of law, have to undertake that assessment. And if the assessment concludes, no, this development can't take place without harm or a risk of harm, you have, to, as a matter of law, to refuse planning permission. Now, of course, that's fundamentally different, and this is the point of distinction, from the position if the site allocations are made. If the site allocations are made, then the developer comes forward on the site to which the site allocations apply and say, well, the plan's committed you not just to development, housing development, to meet your housing targets, but to development on this particular site. That's the distinction. That's why this idea that you rely on all the plans committed to windfall or whatever just doesn't answer the hard-edged legal analysis which you'd have to do under Regulation 63. That's why it doesn't give rise to the risk, unless, of course, the future assessment concluded there's no harm. But if there's no harm, there's no offence to the regulations. That's the first point. Second point is on paragraph 10.6 of the footprint survey. Can we just turn it up? Because with respect, there's a bit of sleight of hand in what Mr. Henderson says. It says as follows. So this is, do you have it? 10.6. I believe that's right, yeah. 73 internal. So, diverting visitors away from the SAC by providing AGS is one mitigation option. Suitable SANGs are a key component of mitigation approaches around other heathlands, such as Dorset and the Thames Basin Heath. In these areas, so that's plainly a reference back to those particular areas. In these areas, such as Dorset and Thames Basin, SANGs are considered as suitable mitigation only for development setback. So all that is saying is that in relation to other European sites, it has been concluded, other particular European sites with other particular characteristics, it has been concluded you can't have development within 400 metres. And we got into the detail of why that might be and why it might be different at other sites. But it's not saying there's a general, that's certainly not saying, and can't possibly be saying, there has to be a general rule that no European site can have residential development within 400 metres. And as I said, if there is such a rule, then the logic of Mr. Henderson's case commits him to saying, well, we have to have, to comply with the regulations, we have to have a 400-metre exclusion policy for all of the other European sites affected by the plan, which he's not saying. But in any event, if you just go back to the paragraphs I showed you, I won't read them all out, but it's perfectly clear that they are considering mitigation generally, not just including for the sites which prompted all this, which is our site, which is adjacent to the common. It's considering the possibility, it's not ruling out the possibility that the mitigation won't work. I think those are the main points I wanted to make. Mr. Henderson says, well, he did take you to the HRA. Of course he did, I didn't mean to suggest otherwise. The critical point, though, is when he was asked, when I said, no, there's no evidence to justify the generic proposition that you don't have development within 400 metres, he goes to footprint. For the reasons I've given you, footprint doesn't do the job. He doesn't show you where else the HRA does the job. And if you go back to it, I think it is 4.2.335, it says, well, having regard to the footprint survey, but it doesn't explain how you get from this, which as I've just shown you doesn't say you can't mitigate the impacts, to the need that it will be unlawful not to have this policy. And there can't be an explanation for the logical reasons that I've given you. That's the point. So those are the submissions.
Thank you. Mr. Henderson will have
Yeah, I can be really short.
one last go. Very good.
So the first couple of points that were taken together about housing targets, where's it going to be, the critical word here is uncertainty. We're dealing with a plan level, and we are faced with uncertainty. We've shown evidence of windfall. What we haven't shown you is, we've shown you evidence of windfall above what we need, but what we haven't shown you is where we can't. That's by its very nature windfall. So this HRA is saying, well, look, this is baked into your numbers, but can we locate it on a map? No, we can't. There's uncertainty, so we address that uncertainty. It's really straightforward application of the Habitats Regs. Second point, Mr. Bewley says rhetorically, well, what about other European sites? The thing about other European sites is where you look at each individually, susceptibility, pathways. Is there an issue of recreational disturbance? What we've done through all of these assessments is highlighted this as being the issue that needs to be addressed. So there's nothing inconsistent in the way that I put the case there. Finally, footprint, the having regard point, the CYC 45 issue, is I just simply invite you to reread that section as a whole. I gave you the references earlier. It follows, I may not use the legalese that Mr. Bewley and I have, but it follows essentially the same analysis that I've set out for you. There's some uncertainty. We can't rule it out. what do we do about that uncertainty? We implement this policy because it removes the uncertainty and we pass Reg 105. Totally orthodox and frankly very unsurprising.
Yes, there's clearly a lot to think about.
Yes.
Think about there, and I think it does tie back to what we discussed in July.
Inevitably, there's
Too.
overlap,
I mean,
yeah.
I think we spoke that day about a number of options that were available to us as inspectors, but clearly this bears quite this question bears quite heavily on that too. So,
Yes.
whatever we do with those allocations, there will be an implication for this policy.
Absolutely.
Yes. That's been most helpful. Thank you.
Thanks, sir.
Thank you both. I'm going to move the discussion on. GI3, which is the Green Infrastructure Network. Does anyone want to raise anything about this one? It's been proposed to be, part of the supporting text, I suppose, is, yes, it's paragraph 9.9, isn't it? It's proposed for amendment. I don't know if the council wanted to touch on that briefly.
Certainly, sir. There's not a huge amount to add to what we've provided in the hearing statement, other than to acknowledge the modification that's proposed, which just provides some clarity in regard to the green corridors that are referred to in the policy itself, and where those can be found to aid prospective applicants in their considerations and assessment against the policy.
Anyone want to raise anything about GI3? GI4? Should I ask, did the council want to say a few words about it first?
So no, we'll just deal with it as it arises.
There's a minor change proposed, isn't it? But yes, carry on.
Thank you, sir. Yes, this is just a matter in relation to GI4. I have to admit, I've always thought this was G14, so I've learned something today. Thank you. But GI4, nevertheless. So the question before us is, will policy GI4 offer appropriate protection for trees and hedgerows? Our view, as put forward in our written statement, is that it actually offers a too great a level of protection. We've set out why in our statements. Just to summarise that briefly, it's in reference specifically to Roman numerals 2 and 3 of the policy. And again, I must just apologise because I've incorrectly labelled those Roman numerals in my statement, but that's a very minor point. But yes, it's Roman numerals 2 and 3, which talk about providing protection for overall tree cover. So this is not just TPOs, this is overall tree cover, as well as existing trees worthy of retention. So again, these are not specifically identified trees subject to any TPO. So it talks about protection for trees of that nature, and then goes on in Roman numeral 3 to talk about trees and hedgerows generally, so both in conservation areas but more widely. And yeah, I think our point is that as currently drafted, this policy doesn't offer any suitable support for development proposals that may result in loss of such tree cover and existing trees, where this is required to enable sustainable development, and where suitable mitigation, either in the form of replacement planting or landscaping or indeed other measures, can be provided. So just to give an example, and obviously the example I'm going to give is British Sugar, but as part of the British Sugar site, there is obviously a permitted scheme that does seek to ensure wherever possible that any trees worthy of retention are retained, but clearly there are also significant infrastructure requirements, including remediation of the site and the provision of suitable development platforms for future housing development that inevitably result in some loss of overall tree cover, as is defined in this policy. that loss is mitigated for through replacement planting of some significance on our scheme. But as it's currently worded, this policy, to my reading, wouldn't seem to allow for that or support those kinds of development. So, therefore, our view, as we say in our statement, is that in order to be effective and to ensure that new development is not unduly stymied, this policy should recognise that such existing tree cover and trees worthy of retention should be retained wherever possible, but in the context of necessary infrastructure provisions for future development and as informed by appropriate master planning and in particular arboricultural survey and assessment. And it should therefore allow for, where appropriate, the loss of such existing tree cover where that is necessary to enable development, and where appropriate, mitigation in the form of either replacement planting and landscaping or other measures can be provided. Thank you.
So a really short response on this. We understand the concern being raised. We will draft something that deals with the general point. I'm afraid I don't accept the suggested wording that's in the matter statement from Mr Jones, but we certainly understand the need to deal with circumstances where there may be some loss of existing tree cover or existing trees, and how that's dealt with by way of mitigation or I should say replacement. That point's taken. We will come up with some wording. I'm afraid it won't be what's before you, but it will be, how can I put it, on the same lines, and we'll take that on board.
That's helpful. I think I would have suggested as much if you didn't beat me to it. Mr Jones?
Well, I'm disappointed that you don't want to use my wording, but yes, that's very helpful. Thank you.
Very good, thanks. Anything else on GI4? Oh, Ms Hilton, sorry.
Thank you. Yeah, just to say, you've probably read the hearing statement from the Civic Trust regarding this. So on page 5, they mentioned that veteran trees and ancient woodlands aren't specifically mentioned in the policy, and we would say something similar, because there is rather a lot of veteran or possibly even ancient trees on the sites in Heslington Parish. And indeed, it would be nice to think that they had all been mapped before any planning applications came forward for future consideration.
I can come back quickly on that. So the additional modification proposed to GI2 includes a reference to ancient woodland and veteran trees, and I would hope satisfies Ms Hilton in that respect. The request to map trees is not something that we consider necessary for soundness or proportionate to the needs of the evidence base. It's 5, yes.
Thank you. Yes, I suppose it relies on this suite of policies being read together, but of course they would be, or they ought to be.
Yeah, absolutely, yes. We didn't see it necessary to duplicate a reference in across 2 policies. I think it's adequately covered.
And presumably, a planning application came forward on a site that included ancient woodland or veteran trees. You would expect some sort of tree survey or arboricultural, I can never say that word, report to accompany it.
Yes, to provide that justification for whatever was necessary to the tree, yeah, impact on the trees.
The question always is what happens to the trees before the application is made, but that's not a matter for the plan, is it? Unfortunately. Yes, thank you. Anything else on GI4? GI5, protection of open space and playing fields. Yep, carry on.
Just another hopefully quite brief point. And again, this is all set out in our I think there's 2 points really here that are raised in our statement. The first is to do with, I think, the second paragraph of GI5 as currently drafted, and I don't think there's any mods that I've seen to this policy. So the second paragraph currently says, where replacement open space is to be provided in an alternative location within the area of benefit, the replacement site facility must be fully available for use before the area of open space to be lost can be redeveloped. And so our point to raise, I think, is that, again, giving an example to illustrate this, and again, my example is British Sugar, obviously, but at the British Sugar site, as part of the permissions that have been granted for the redevelopment of the site, there's a combination of on-site open space and playing field provision together with a commitment through the 106 agreement to a contribution towards off-site improvements in the locality. And in terms of those off-site improvements, the timescales for the delivery of those off-site improvements are actually, in our example, in the control of the council, because they relate to contributions towards a council-owned site. So again, I hope a relatively simple point, but our submission is that in order to make sure that this policy isn't unnecessarily delaying or precluding developments like ours, it would need to be more flexible and include appropriate flexibility around the timescales for provision of replacement open space facilities to ensure that kind of situation doesn't arise. So that was the first point on the policy as currently drafted. And the second point is perhaps a more general one, but there's a couple of references in the policy to area of benefit. And I personally couldn't find anywhere any definition of what that is. I mean, it's clearly very open to interpretation, and I appreciate it would be dealt with possibly, you know, on each site-by-site case. But my suggestion really is that really needs to be more precisely defined or clarified in order for this policy to be clear. That's it. Thank you.
Thank you, Mr. Jones. I'll hand over to you.
Taking the first point regarding the time frame in which and the order in which the open space or the re-provisioning of open space should be considered, we don't accept the point that we should modify the policy as proposed. The starting point is one that is expressed in the policy that that re-provisioning should be made available in advance of any loss. If there are exceptional circumstances that arise with a particular development proposal, they would of course be material considerations that would form part of the assessment, and any subsequent agreement dealt with through section 106 or otherwise. So we would maintain the position on that and think it's right and proper planning to set that preference out in the policy. The reference to area of benefit and its appearance in the policy and what that relates to, that's not specified any further because it would relate directly to the particular open space that we're talking about. The open space definition relates to quite a number of different open spaces. So it could be a localised play area, or it could be a sports pitch that serves a much wider population. So the area of benefit is specific to the open space that's in question. So again, I don't think that necessarily needs modification in the policy. We would, or we could look to perhaps review the explanatory text and, if necessary, provide a comment in there to aid that interpretation.
Yeah, that might be worthwhile. I think I understand now. Now it's been explained to me, but yeah, it could perhaps do with a little more definition.
That's quite fine. We will do that. So.
Can I ask though about the example Mr. Jones gave? If that kind of proposal came forward, where it was a combination of some on-site and then a contribution towards off-site improvements, which would obviously take place after planning permission was granted, because then the 106 would be signed. You wouldn't sort of turn away an application of that sort on the basis of this policy simply because you'd think about it in the round? Am I understanding that correctly?
So yes, and also in that off-site circumstance, what would be included in the 106 would be the contribution.
Yes.
So you would set the trigger for the payment of that contribution to the relevant time, and so long as that's paid on time, that it could fall within the terms of the policy, because that money would be provided to the council such that they could make sure that replacement site or facility was fully available for use before the area of open space to be lost can be redeveloped.
Okay, so...
And if the council is slow, well, that's not the developer's fault.
Once you'd granted planning permission, subject to the 106, you'd have no control over implementation. It would just happen unless there was something in the 106 that was agreed that had triggers.
Exactly. So it could be, for example, payment of that contribution 2 months before the commencement of development, and then the council has 2 months in which it would put in place that. I mean, I use that as a totally hypothetical example, but what I'm trying to say is that circumstance is catered for by the policy in the way that's drafted.
Mr. Jones, was there anything you wanted to add?
I don't actually agree that it is catered for, I have to say. I think the word must is a key word here. If the council want the policy to be applied in the way they've suggested, my view is that should be should. Must. In my experience, when officers come to apply such policies, the word must means must. My experience is that in applying such a policy that they would take that as it's written, and that my example that we've given, which is an already permitted scheme, would not comply with that policy. So I don't think it does work. I think that I take the point that it would be applied in the round with other policies, but I think that should be made clear in the wording of the policy.
That's helpful. I'll leave that with you.
Yes, sir, yes. I mean, I think we probably will look in the first instance to the support and test. Insofar as we want to make some clarification on that, I think we would resist changes to the policy. You can always flip this around. Imagine it's on a Section 78 appeal and the developer says, well, here you go, here's your money, and you can deliver the site, so why are you saying it's not available? You know, there's a degree of realism, I think, in my submission.
I understand. I'll leave it with you, but I do think perhaps something in the text needs to be added to allow for some flexibility, to give some comfort.
Indeed, we can look at that.
Thank you. Thank you. I'm going to move on. Oh, Mr. Merritt, did you want to talk about GI5? Go on.
Thank you. We are concerned that the policy is inadequate as it is. When we made our original submission, SID 364, in paragraph 3.4, we flagged the issue of pressure on playing field space in the city. You know, we actually mentioned a couple of specific sites. The playing fields of the former Manor School site, the former Lowfields school playing fields, and the former University of Ripon and St John playing fields in Hull Road, all of which had some degree of previous use by voluntary groups in the local community besides the institutions that were that used them as well. And in fact, it was part of the planning permission for the John Lloyd's Centre and that site that it should actually provide community provision. In the 4 years since that point, we've lost all of them. And that basically is part of a longer-term trend that, in effect, there's progressive loss of sites within the urban area. And people fall back on the argument, well, we're re-providing new sites, usually just on across the draft green belt boundaries in the green belt. Well, the problem with that is it makes it more and more difficult for the communities that aren't near the edge of the city to access a playing field and open space. And, you know, in effect, those communities become more deprived, they undertake sports less, and it's not helpful to the health and well-being of the population in the city. So we would certainly like to see this policy tightened up, and we'll make some similar comments in terms of the following policy, GI6.
Are you worried that it gives the facility for replacement open space in an alternative location?
It also doesn't take into account what typically happens when the existing institution finishes, that at that point, the institution basically stops local clubs and others using the facility. In some cases, that has led to the collapse of the club. In other cases, it's pushed it further afield, and then makes it dependent on car transport for people to get to the new sites, and makes it very difficult for those people who, for kids and others in families that do not have access to cars. So it actually contributes to increasing deprivation for the most disadvantaged sections of the community. So, as I say, we'd like to see the policy strengthened. We'd like to ensure that it takes account of the use of those sites prior to the discontinuance of the previous usage, so that it gets around the problem of the site being arbitrarily shut down, and then a few years later, when it's you look for redevelopment, well, it's not being used.
Mr. Henderson?
Yeah, 3 short points, sir. Firstly, the question of being pushed to the edge of settlements was the first concern raised. That is adequately catered for in my submission here because of the area of benefit provision, so precisely to prevent such matters, so no need to tighten further. Second concern that was raised was about loss where it was, in general terms, I don't mean this to discredit, it's about important open space. But that's dealt with the second bullet point, because the loss is only permitted where there is a surplus. So we're striking the balance there. And we say we don't need to strike that balance in any other way or to tighten it up. And thirdly, the suggestion that what landowners are doing and the approach there, that is very in large part so outside the confines of the policy before you. I don't see how we could redraft the policy in order to deal with that. I'd have some serious concerns if we were to try. But fundamentally, those sorts of issues are development management. If there's a long-established open space and it hasn't been used for a relatively recent period of time before the application goes in, well, the officer has scope and flexibility to make a judgment in those circumstances, that judgment may be, well, yes, you haven't used it over the last 6 to 12 months, but we still have a piece of open space which falls within the protection of this policy. But that's all development management, site-specific. It doesn't need to be part of this policy. And indeed, I'd have serious concerns if we were to try to include it in that way.
It's another how far can you go with a policy point, isn't it? When there's development management to think of too. Mr. Merritt, was there anything else on that policy?
Well, I'd just come back to the point. The policy is failing. It's basically the existing policy. It's failing to protect sporting and other facilities in the main, more central parts of the urban area. Part of the problem with the council's strategy is they've segmented the city in terms of how they do the assessment. So in effect, part of the city centre is in the same segment as parts of the outer part of that quadrant of the city. And as a result of that interpretation, we lose the more central sites on the basis that they can be accommodated at the edge of the city, and they're far too far away from some of the more central parts of the city to serve the function that is required. So the current policy is failing. It's not adequate.
Is there any way that point can be addressed, or is that simply a matter of how the council approaches this area as a benefit point?
Indeed, and it's the approach that's taken and considered through the playing pitch strategy or any other open space strategy in which the policy relates back to.
Okay, Mr. Merritt, did you have some points about GI6, unless anyone else has got anything on GI5?
Yes.
Carry on.
GI6 are very concerned at the recently published modifications, which effectively rip out two key parts of the existing policy. One of the problems that you get here in the city is in terms of, if you do this strict proportionment to particular sites, then a development site comes along, it probably justifies half a playing field, sports playing field. So you don't get the sports playing field provided on that site. Another site comes along, it justifies a third of a playing field, so that site doesn't provide a playing field. But cumulatively, the level of development in an area would certainly justify additional playing fields. And that was the function of the second paragraph that's largely been crossed out in terms of trying to ensure that an intelligent approach is adopted in terms of how you use the reasonable allocation of space on individual sites in a holistic way to deliver the range of facilities that the collective increase in development would justify. And then the second change that has been made is to delete what was a separate Roman numeral 2 exceptional circumstances test, which was also about trying to ensure that there isn't this tendency to offer something miles away as a satisfactory scale of provision.